Good morning, everyone. Today is Thursday, the 18th of January. We're midway through the first month of 2024. I'm delighted to present to you Linda Duffy. She's been here many, many times, and every time she's here, we always learn something new. I asked Linda if she wouldn't mind telling us what the new year laws are and how it affects you as a business owner. So we just want to make sure that you guys are all on board with the latest and greatest. And Linda is a really good friend of PayrollCentric. So Linda, I'm going to let you tell us a little bit about yourself. I'm so excited that you're here. Thank you for taking the time. And as always, we're going to be full of information by the time you're complete. Thank you so much for joining us, everyone. Here you go, Linda.
Thanks, Sandra. Happy New Year, everybody. Like Sandra said, I'm constantly surprised when I look at the calendar and we're already a 24th of the year through. So just crazy. So you can read all about me. You don't need much of that. I will tell you, this is sort of our agenda. What I try to do is group all of the California things together first and then have a few slides specific to federal law, because I understand some of you may not be based in California. So not knowing where you're from, Sandra gave me an idea of where some of her clients are. And so we'll talk just a little bit about that toward the end. So for those of you in California, you know probably that the minimum wage increased to $16 per hour effective January 1st. So depending on what industry you're in, it may be slightly higher, but you should all go back and make sure that your employees are making at least $16 per hour. There are also local ordinances. There's about 30 that I know of across the state where the minimum wage is actually higher than the state average. So most of them are in Northern California, like Mountain View is at $18.75 an hour. Emeryville, which was in the lead, was at $18.67, like that. So you need to always make sure, and it goes by wherever the employee is working. So somebody could be working remotely from their house and live in Mountain View, and you would need to pay them the higher minimum wage. In Southern California, Los Angeles City is at $16.78 an hour, and San Diego City is at $16.85 an hour. So again, you always want to take a look at what the minimum is for local ordinances as well, and then your requirement is to pay whatever the higher amount is. The other thing to keep in mind, a lot of people forget this, is that for the state of California, the minimum salary to be exempt from overtime, so most people think of salaried, is twice the minimum wage. So in this case, it's $66,560 a year. So if you aren't paying a salaried employee at least that, automatically you're not in compliance with the law. There's still a duties test on top of the salary test. There's a two-pronged test, but at the very least, when we go in to do an audit for a client, you know, we just say, give us a list of your employees, tell us if they're hourly or salaried, and then we take a look at their compensation. So this is an easy one, you know, to be in compliance with, but also an easy one for any authorities to catch if they come in and audit you. So those are some of the things to think about where it comes when we're talking about minimum wage. Paid sick leave also increased effective January 1st. So you might remember that before it was 24 hours or 3 days, whichever is greater, and now it is 5 days or 40 hours, whichever is greater. So you can still accrue it, but we will just tell you it's not worth it if you ask me, unless you have a lot of people that are very part-time. Otherwise, just front load the sick pay and be done with it. Just give everybody the 40 hours up front. But those of you that started this in July of 2015, when the original law went into effect requiring sick, you have a choice. If you're front loading, as of right now, front loading July 1st, you can either add the 16 hours and then on July 1st, add 40 and just keep that your year. Or you can give people 40 hours right now and then just have everything be January 1st. They didn't really do a good job thinking this out, obviously, when they passed the law, because I think they forgot that everybody was on a July 1st schedule, or most people were. You can still accrue. You can use the state accrual method at 1 hour of paid sick leave for every 30 hours worked. You have to keep in mind, though, that if you have a different accrual system, you want to make sure that you're in compliance with various parts of this law in terms of how much time they have to have at day 120, how much time they have to have at day 200, I think is the other one. So you just want to make sure that you're in compliance with those things. Like minimum wage, there are also local ordinances that offer a higher benefit. Los Angeles, for example, is at 48 hours. So you always have to take a look at that. The other thing I wanted to just mention here is some companies decided a few years ago, this was the trend, let's combine paid sick leave with vacation and just call it PTO, paid time off, and just roll with it that way. It's easier to manage. People can use the time however they want. I'm here to tell you, don't do that anymore. Separate the two out. And there's a few reasons for that. One is upon separation in California, you have to pay all monies due and any unused vacation time. You do not have to pay out unused sick. If you combine them into PTO, however, you have to pay all of that out. So that's an expense that you don't need to incur. The other thing is you have to always comply with the higher standard. And if you combine the two, you have to apply the vacation standards to sick and the sick standards to vacation, which makes it a little bit more complicated. Sick pay is supposed to be paid out at the employee's regular rate of pay, not usual rate, but the regular rate, which is a calculation including, bonuses, commission, other incentive pay. Vacation doesn't. Combine the two, PTO has to be paid out at that. So there are a lot of reasons to keep them separate. Okay? A few other things about paid sick leave. The paid sick leave policy has to be in writing and disseminated to all employees, right? So you don't have to have a handbook in California. We certainly would recommend it once you get up to like 10 employees or more. You don't have to have one, but you do have to have certain policies in writing. Paid sick leave is one of them. Then you also should be updating your handbook if you do have one, but at the very least, writing your sick pay policy and sending that out. And there's this other notice in California, we're required to give all non-exempt employees when they're hired. And also if there's a change, I'll talk about that in a second. Part of this form has the new paid sick leave requirement. So you need to change that section on your wage theft notice or your section 2810.5 form, however you want to call it, and make sure that that's now updated to say the 40 hours and the 5 days. And it's my belief you also need to reissue it to all of your non-exempt employees if in fact your policy is changing now. You also have the requirement to notify employees in writing how much sick time they have available, which is another reason not to combine it with vacation. And make sure that's on the pay stub, or you can, if it's not on the pay stub, issue any other, writing to notify them. The other thing that changed in the wage theft notice effective January 1, I wish I could even explain where this came from because I have no idea. You need to add this question. In the past 30 days, has there been a federal or state emergency or disaster declaration applicable to the county or counties where the employee is to be employed? I have no idea why that's relevant to anything, how it helps an employee to know that, but nevertheless, this law was passed. So that's a second change you need on your wage theft notice. I didn't even know how you get the answer to that question, to be honest with you. I was doing this presentation yesterday, and a woman in the room said, well, we're always in that state because of fires in California. So I don't know, but I didn't even know how to get that information, but you're required to put on the form. So good luck. And if you know, let me know. All right, cannabis. So this one's a little tricky. Basically what the legislature did is say you cannot test for pot unless you have a way of essentially showing that they're currently under the influence. I'm paraphrasing with my language, but that's what they're getting at. Because it's a legal substance, they don't want employers drug testing and firing somebody for pot showing up in their system when the half-life of pot is like 60 or 90 days, meaning if you smoked a joint on Saturday night, it could still test positive in your system 60, 90 days from now. So they want you to have to test for like I don't even know how to say the words, like make sure that the person is currently intoxicated, if we can use that comparison. And unfortunately, I don't know of many labs, if any, that know how to do that yet. So make sure if you are doing drug testing, you either tell them not to test for THC or you ask them if they're in compliance with this law so they have the ability to test. It's not quantity and quality, but I think you know what I mean. Like, is this person currently under the influence or impaired in any way? If you have government contracts, you may still be able to just hang your hat on the Drug-Free Workplace Act, because that's a federal law, and pot is not, or THC is not legal under federal law. So just make sure you're talking to your clinic or wherever you send employees if you are drug testing them. Make sure they're compliant with this. California has another leave of absence. It is an unpaid leave, but it does apply to any employees with 5 or more employees, and that's reproductive loss leave. So this applies to men and women if you have a miscarriage, if you were trying to get pregnant with a surrogate and it falls through, the stillbirth, a failed adoption, anything like this affecting, a new baby. If something happens, then the employee is allowed to take 5 unpaid days off. They do not need to be consecutive. I can't remember exactly in what time frame. I think it's 90 days. They have to take the days, but they can take the days for whatever the reason they want relative to one of these issues. And as an employer, you cannot ask for documentation to support that. So presumably anybody could walk into your office and said, I or my wife or somebody just miscarried, and you'd have to give them 5 unpaid days off. So make sure this is in your handbook as well. This is a really scary law, if you ask me. So this was Senate Bill 497, and it basically says if an employer takes any sort of action against an employee, some adverse action, a negative action, within 90 days after the employee engages what they call a protected activity, then it's going to be presumed that it was in retaliation. So engaging in a protected activity could be taking their sick pay. It could be complaining about their wages. It could be a whole host of things. And if you write them up, if you fire them, if you do anything, even if it's not related to this, they're going to walk in assuming that it was in retaliation for whatever action the employee was engaged in. So I don't have a lot of advice on this other than know that it's out there. Be thoughtful about your documentation before you fire employees. Make sure that people are not retaliating against employees for things like, having a sick day and things like that. All right. So the next thing, The next thing is non-competes. So I know a lot of my clients would love to be able to have all of their employees sign a non-compete. If you leave me, you can never go to a competitor. Unfortunately, and this has been trending this way for a long time, in California, not only are they unenforceable, which before we'd say, well, put the language in, the employee doesn't necessarily know that it's not enforceable. It's just like a scare tactic. Now that's specifically illegal. It's unlawful to include any kind of non-compete language in agreement or have an employee sign a non-compete agreement. Don't put it in offer letters, anything like that. Not only that, now this particular law, there's 2 actually, Senate Bill 699 and Assembly Bill 1076. Now you actually have an affirmative obligation, meaning you must go to your current and former employees who might have signed some non-compete language, whether it was an offer letter, a standalone agreement, anything, and you must notify them that it's unlawful language. So I don't know why they caused that to happen as opposed to just, okay, so we know that you can't do it going forward, but you have that obligation to go back even to employees that don't work for you anymore and notify them that that language is unlawful. The other thing that's important about this, they don't even have to suffer monetary damages. They would still be entitled to penalties, including their legal fees. Those of you in the fast food industry, there's a few things that happen, including the minimum wage for fast food. It's, I think, at $20 right now, and it's on a scale to, go up to $25 an hour. So I didn't talk about that minimum wage, but that's, there are some industries like that. This fast food council that's managing the minimum wage also said if you have food handlers, you have to pay for them to get their card if they don't have it. All right, artificial intelligence. If I was in a room, I'd say, how many people have tried it? A lot of people really like playing around with AI apps and, Chat GPT and everything like that. But it can go horribly wrong. So with artificial intelligence, just know it can be fun. but you can also get into trouble with it. And I'll give you a couple of examples. There were attorneys, and I put in here, insert attorney joke here, right? Attorneys used it to redo research for a case, which is great, except ChatGPT made up some citations. They quoted them in court, and then they got sanctioned because of it. Okay, so you cannot rely on the accuracy of the information. I worry about clients who are going to go out and say, hey, ChatGPT, write me a employee handbook or something like that, because you're not going to know where they're pulling their information on. Their information right now, I think, because I was looking around on it last night, is as of April a couple of years ago. So they don't even have the most recent information. They can't scour the web usually unless it's paid application of it. Even then it's questionable. So just be careful. There was also a company that the EEOC, the Equal Employment Opportunity Commission, which is federal, they fined a company because they were using it to screen resumes. And the EEOC believes that ChatGPT to be used for that purpose shows bias and can be discriminatory. And so they were cited for that. So there's a lot of different things. You also never want to upload your intellectual property, any company confidential information, because once you upload it to them, they can use it for whatever purpose they want. So it would be out there, and that may jeopardize any trademarks or anything like that you have. So what we do is we added a paragraph to our employee handbooks this year, just recognizing some of the issues and making sure that employees always notify their boss before they use it for any work-related purpose. Arbitrations. So, some point last year, I don't remember when, Sandra invited me to talk, and I think we talked a little bit about this. Arbitration agreements, this part of the law changes, it seems like daily. So just in the last couple of years, we've had to modify our agreement multiple times. As of right now, you can still use arbitration agreements in California. You want to have an attorney write one or engage somebody like Ethos to help you with that, because we have one that our attorney blessed. This changes all the time, so you just need to stay on top of this. But we do recommend using an arbitration agreement. The cons are that you have to pay for it as the employer, and that can be expensive. But the pros are that it usually resolves matters a lot faster. It's usually cheaper because you're only paying your attorney for a day or two as opposed to preparing for a whole trial. You are not likely to end up with crazy jury awards and punitive damages and things like that. So there's a lot of, positive things about arbitration. We have a couple of versions, one of them from an attorney who successfully defended making it mandatory. You don't need to fire somebody. What you would do is basically put in your handbook, hey, we have all of our employees sign an arbitration agreement. Even if you don't sign it, this is how we, as a company, have decided to resolve disputes. And then you have them, with a wet signature, sign a separate arbitration agreement. And if they don't want to, then you just notate it was given to them and they refuse to sign it like you would like a written warning. So that's just something to think about. And again, we can help you with that if you have any questions. Okay, I'm not an attorney, but I'm just going to try to summarize these real fast for you just to make the points of what's going on in each of these cases. So over the past year, there have been 3 cases in various stages of appeal having to do with rounding. And I'm here to tell you, just don't do it anymore. Sandra, I don't know if your system allows for rounding, but we always discourage our clients from doing it because you have to be able to prove on the surface it was not in the employer's best interest that it was even. And that's almost like impossible to do. So we just say, just don't do any sort of rounding at all. You can also get in trouble because I've had clients try to round like meal periods, which would be a violation of the law. So we just say, just don't do it. Naranjo, this case basically said that any kind of like meal period penalty, things like that, if somebody doesn't start their meal period before the end of their 5th hour, again, for California, or if they don't, get an uninterrupted break or anything like that, those penalties are considered wages. And why that's significant is somebody leaves the company, you're required to pay out all wages due. So you would have to pay those out as well. And I would say, yeah, of course. But if for some reason you missed one, you didn't do it, and they come to you and say, hey, you owe me this money, you can be fined up to 30 days of their payday, right? So they can get a day's pay for every day that goes by up to 30 unless you pay it. or until you pay it, either way you want to look at that. So that one, just be aware you're probably in compliance with it, but just want to make sure you knew about it. Stericycle said that a rule or policy is presumed to be unlawful if it tends to, quote unquote, chill employees from engaging in protected conduct. So it sounds like one of the laws that I already mentioned in California, but this is also protected conduct under Section 7 of the National Labor Relations Act. So everybody's covered by that, not just unionized workers. That says things like employees have a right to complain about their wages and working conditions, things like that. So the next one, Groff v. DeJoy, this had to do with religious accommodations in the workplace. So it changed the rules slightly. So everybody again says, yeah, of course, we know we have to accommodate people if they have a religious issue. In this case, it was an employee of the U.S. Postal Service that said, I'm a devout Christian. I go to church every Sunday. I can't work on Sundays. And I believe they hired him under those circumstances and with those terms and conditions. But then at some point in time, something happened where they had to have more people work on a Sunday. And he said, I can't do it. And they just kept writing him up. And he finally quit and then he sued. And the lawsuit basically said, look, unless this is going to be a substantial cost, right, substantial expenditures on behalf of the employer, then you need to accommodate that. So be aware of that. The last one is interesting. So this is Thai v. IBM. This has to do with reimbursement of expenses. So there's a section of the labor code, I think it's 2802, that says you must reimburse your employees for necessary and reasonable expenses incurred in the performance of their duties. Okay. What happened was, you remember we sent everybody home during COVID, right? And so people were working remotely. We said, okay, do we have to pay people for those expenses? Do you have to reimburse them for, if they're using a home computer, their electricity, their Wi-Fi, all of those different things? Companies took different approaches. And this basically said, it doesn't even matter why they went home. Doesn't matter the state mandated it. Doesn't even matter if the employee begged for it. If an employee is working remotely, the employer must subsidize the electricity, the Wi-Fi, any expenses they incur in the performance of those duties. Okay, so we hung our hat before on the word necessary. And after COVID, we said, well, some employees are being allowed to work remotely. They like it. They want to continue to work from home. And the government says, we don't even care why. We don't care if that's the employee, if it was voluntary, if they begged for it, if it was due to a national disaster, doesn't matter. You have to pay for that. And companies can do that different ways. And feel free to drop a question in the chat if you want me to talk more about that. Okay, later in 2024, we're going to have another requirement. This goes into effect July 1st, so you have almost 6 months to prepare for it. And that is, you need to have a written workplace violence prevention plan. So similar, just think COVID prevention plan, CPP, it's almost identical in terms of the same sort of layout, if you will. So there's like 13 or 14 different things that need to be included. You have to do training for your employees. So you're going to have to establish that in the next 5.5 months. Again, we'll be writing these for clients. So if you need help, let us know. And there's fairly similar record keeping and training requirements. There's also some cases pending before the California Supreme Court, and time will tell what happens with. All right. I'm going to move into some federal laws that presumably would also apply to California employees, but we have a higher standard already most of the time, so we don't have to worry about this one. New Form I-9, hopefully all of you know about this. We did a webinar last summer together with PayrollCentric on this. So you need to download and use it. You can just go Google, 2023 or 2024 Form I-9 or current Form I-9, or go to the USCIS has a website devoted entirely to Form I-9, so you can go find it there. You can also watch our webinar that we did last year. It's out on our YouTube channel. So I gave you the exact link. You can also, just so you know, we've got a ton of webinars that we've done over the years, and they're all on our YouTube channel, which is, youtube.com/ and then Ethos HCS. And you'll find a ton of resources there. So the other thing to note, in-person verification, meaning of documents, you need to do a physical inspection, is also back. We had a reprieve during COVID, And then in August, we had to scramble to go back and physically inspect all those documents. Going forward, you have to, unless you're using E-Verify. So for those of you that have employees that are remote, you might want to sign up for E-Verify. There's no cost to do so. You put information in, that way you know you're not hiring anybody who's not legally employed by the United States, and they will allow you to do a remote inspection of documents. So it'd save you some drama, some time, some effort if you do have remote employees and find it difficult to inspect the documents. The other thing I wanted to mention on this, only use this with new hires going forward, effective 11/1. That's when this went into effect, November 1st of last year. Do not have all of your current employees re-verified. That's actually a violation of the law. So it's just a new version of the form. As you hire people going forward, you're going to use this with. Okay, the PUMP Act is very similar to the the lactation accommodation policy in California. So it has a lot of the same characteristics, and it basically says, hey, if a woman has to express breast milk at the office, she's entitled to a room, not a bathroom, right? Something private, and it should have these things next to it: sink and running water, refrigerator, freezer, all these different things. Sort of weirdly, this applies to remote workers as well. So I don't know how you're supposed to do construction in their house, but that's a whole nother thing. So anyway, it does potentially increase the break time. They're allowed to take additional breaks if they need them. And then there is a hardship exemption for employers that have fewer than 50 employees. But again, the burden's going to be on you to say, we couldn't provide a private room, we couldn't give them more breaks, things like that. Now, the Pregnancy Workers Fairness Act is similar to our California Pregnancy Disability Leave Law. It does not provide for a specific amount of time off like our PDL does, but it does say that you need to accommodate a pregnant woman who may have some restrictions. One of those accommodations may be to give them time off. And so that's something now that's in place nationwide. It's hard to believe sometimes in California because we have so many different laws we have to comply with. It's hard to believe that there was never a pregnancy, disability related leave law across the country, but there wasn't until this one went into effect. And then finally, state resources. So when I talked to Sandra earlier in the week, she told me that she knows that there were going to be people on here from Nevada, Texas, and Utah, and Arizona. And then, maybe scattered. A lot of us, even in California, have employees out of state. So I just dropped into this slide some resources for you. Every state calls it something else, right? Texas is the Texas Workforce Commission. All four of these states play by federal laws for the most part. There might be one or two things that have a higher benefit under state law, but for the most part, Nevada, Texas, and Utah for sure. And mostly Arizona just say, hey, whatever the feds do, that's what we do. But you can look up certain things on those links that I'm providing you. And then federally, the Department of Labor has a pretty robust website. So if you aren't subject to California law and you go by federal law, then you could go to the DOL. You can actually search by topic and it'll pull up a whole host of information for you. Okay, so that's it for content. This particular QR code right here, if you'd like to sign up for our mailing list, you can take a screenshot of this right now. We send out one newsletter a month, mostly, almost every month. And almost every month we do a webinar. We have not signed up, or we're not going to do one in January, but we'll probably do one next month. So if you want to get our mailing list, you can do that, or you can just email me right there. Sandra will send out these slides later. And we'll take questions in a minute, but she will send out the slides later and you'll see my contact information on that. I do have an irresistible offer for all of you today. We offer audits, right, to make sure that you're in compliance with mostly California law, but we could presumably do this for any state. The cost of that audit is $24.95. It takes usually 2 to 3 hours. We come in, we peek under the hood, we walk you through soup to nuts from the time you start thinking about hiring someone to the time that they're gone. Walk through all the processes and policies that you have from an HR standpoint, and we issue a written report where we identify the issue, make some recommendations, and then provide you some resources, sort of do-it-yourself situation. If we don't identify at least one area where you're out of compliance with California law, we will not only refund your money, we will also give you a $250 gift card on top of that. So you have nothing to lose, because as a friend of mine always says, if you're thinking that's expensive, my answer is compared to what? Because that lawsuit or that claim by the employee is going to be a heck of a lot more than the $24.95. And with that, Sandra, I'm going to turn it back over to you, and we will go ahead and take some questions.
Wow, Linda, that was so wonderful and so much content. So thank you very much. We do have a question in the chat. They want to know if parking would fall under the reimbursement rule. And there's also a question about a recommended list for what would be reimbursed for a remote worker. So that's a twofer.
Yeah, so, well, I'll sort of answer them together. Yes, parking would be if the employee has to drive for business, right? So here's what you don't have to reimburse for. You don't have to reimburse mileage or time for what's considered a normal commute, right? The employee drives to the office, you don't have to pay for that. But once that employee is at work, if you send them to a client, if you send them on an errand, if you do anything like that, now you're responsible to pay for that time, and you're responsible for reimbursing mileage. You don't have to use the IRS rate, although we would strongly urge you to use the IRS rate, because once again, you would have, as the employer, the burden of proving that the amount that you reimbursed did in fact cover their expenses. How are you going to measure the wear and tear? How are you going to measure, how much gas they actually use, that type of stuff. So if you just reimburse at the IRS rate, it's not a problem. None of the laws that have been passed or the cases that have been settled ever tell us exactly how much needs to be reimbursed or gives us any guidelines for reimbursement. All I can do is tell you that, again, the section of the labor code says any necessary and reasonable expenses incurred in the performance of the duties. So what does that mean? Well, if you're in the office, maybe they have no expenses, right? If they're working remotely, as we talked about before, they're using their own electricity, their own Wi-Fi. My employees use their own computers for the most part. So those are the things that come to mind. What we've done as a company is we just have a home office reimbursement. It automatically shows up on their check. We're a semi-monthly payroll service, or payroll schedule. So they get, full-time employees get $50 twice a month, and part-time employees get $25 twice a month. So that's what we've done. And that's, to cover their cell phone, cover everything else. Somebody on site may need to use their cell phone. I don't know. Certainly if you have drivers or somebody that's going out in the field, they're going to need their phone for navigation, for keeping in contact with the office, for, clocking in and out probably. So you would want to reimburse them something toward that. Everybody's got unlimited time these days, right? So long ago, I remember we had to line item every phone bill and say this was work related. And we don't do that anymore. We just say, okay, this, we're going to pull a number out, right? It's going to be $10 a month. It's going to be $20 a month, whatever you think makes sense. And unless an employee challenges it, then I wouldn't worry too much more about that.
And then the follow-on question is parking. Regarding the parking, is it just for the on-premise parking in a normal workday, or would it be if they went to an office for a visit and had to pay that parking, or both?
It could be both, right? So I don't know that you would be required to pay, like, let's say you're in downtown Los Angeles, right? And your building doesn't offer parking. And so people have to park at a local, parking lot. I would say a lot of employers are going to pay for that or reimburse it, because otherwise they're not going to get anybody to come to work for them. Is it required by law? No, probably not. However, if you send them to go to a client and they have to pay to park there, absolutely, that has to be reimbursed. But sort of, I think on the first example, that's probably considered part of like normal commute and normal everything else. But you also have to keep in mind, okay, I may be compliant with the law, but am I going to be able to retain any employees if they're paying out a ton of money every week just to park so they can come to work?
Good advice. We do have some companies, just for your information, that they do come up with a basic amount. And like Linda said, they just pulled a number, probably taking a poll. What is your average electricity, or what is your average amount of water that you might be using, or what's your Wi-Fi cost? And they've come up with a number, and we have set it up on their payroll that, just like Linda, they get either 50, 25. Some companies just do a blanket. Every year they get a blanket amount called office reimbursement expense. So it's something that would be really important for you to take a look at. And like Linda said, it's less expensive to do that small amount than somebody coming up and suing you if you have to terminate them or whatever for those legal fees and things like that. So I'm not allowed to give you advice. I'm just letting you know what PayrollCentric does, that you're in the know.
I am allowed to give you advice. That's what I get paid for.
You are. That's right.
Yeah,
That's right. But not me.
So, and just to follow up on that, like yesterday I said I was presenting new laws to a different group, and somebody in the room said what they do is we were having a discussion about whether if you reimburse a certain level for one employee, could they do it the same for all employees? And I said, not necessarily. You could distinguish by, like position, for example. So if you have drivers, you wouldn't necessarily have to reimburse everybody else for cell phone usage if they're not using it for work, right? Or maybe it's a lesser amount or a larger amount, depending on what the role is and how much phone usage they have. What this one woman said is they have people bring in their cell phone or their like Wi-Fi bills, cell phone bills, and they pay a percentage. So if your cell phone cost is higher, you may technically get more dollars, but you would be getting the same percentage. So there's different ways to do it. Just pick a way, be consistent, keep the records, and you're good to go.
Yeah. Okay. And then I have a question for you, Linda, actually a response. With the timekeeping system that PayrollCentric offers, the benefit of that is that it is a time clock in, clock out to the minute. And so there's no rounding and there's no chance of rounding. What we do on occasion is some companies have a finger or a biometric clock, and there's a line, to clock in by 8 o'clock. They have like a 3 to 5 minute grace period in order to accommodate that line so everybody can get clocked in and still be considered on time for work. So we can set it up that way. We can also block early clock in from lunch so that they don't have that meal break penalty, which is really a penalty for you. Instead of a 30-minute lunch, you have to pay for the hour. And so we can block if they, try to clock in at even 29 minutes, not 30, it can be blocked so that they cannot clock in less than 30 minutes for that lunch break. Some companies also... Yeah. And some company also, I even had a meal break penalty. So, there's some things that you have to really watch carefully. So it helps you from not being able to do that. The other thing that is important to note is some companies have breaks that are scheduled and they ask their employees to clock in and clock out for the breaks. The companies that started doing that kind of stopped doing that because it became an administrative nightmare. And so they put their employees on an honor system, because if I go to a break at, say, 10 o'clock, come back to work and the phone is ringing at 10:15, I forget to clock back in, then there's a penalty because I didn't clock back in and the administrator has to do that manual entry. So it really is up to you and how many employees you have. But break times could really be on the honor system if you want them to, or we can also set it up so that they have to clock in and out. It depends on how much administrative time you want to have for editing punches. Okay. Anybody? Oh, somebody asked about parking tickets. I don't know. What do you think, Linda? Is there a reimbursement if you get a parking ticket because you had to park on the street and you worked too long?
Yeah, I don't think so. I think the employee is hard pressed to make that argument, but every case is going to be probably different on that one. Were their circumstances beyond their control, or were they just foolish, right? So I don't think I would have a policy one way or the other than to look at each case on a case-by-case basis. Certainly if they're like speeding or something like that, I don't believe that the employer has a responsibility to reimburse.
Okay. Are there any other questions on this topic? Any others? Okay. Well, if you think of something afterwards, of course, my email address is in the chat. You can always email me. And I did take a picture of all the people that are on the webinar right now, so I can send you, if you would like, the copy of the slide deck, because there's so much really good information in there. Or you can do like Linda said, this will be uploaded onto our YouTube presentation, and it's PayrollCentric presentations on YouTube. And then Vimeo is also active, and we'll be putting that link in there, and it will be uploaded to Vimeo as well. So you've got an opportunity to see both. And Linda has just put her email address in here as well, so she can answer questions or also send you her deck. I keep the deck also in perpetuity. If my computer's ever gone, we can always get a hold of Linda, but I do save these decks. So if you think about it later and say, yeah, I'd really like it, please send me your email address. With that, thank you so much for joining us today. I'm very happy that you're all here. We had a great participation, and I'm looking forward to next week. And Linda, again, thank you so much. You are the best of the best, the most knowledgeable person in this field that I know. And I'm so grateful that you always say yes when I ask. So thank you again for that.
Appreciate the invitation. Have a great week, everybody.
Bye, everyone, for now.